I'm ready.
We're missing Mayor.
Okay, we will return to open session, and I will turn over to Christy Slay, our
Christy
legal
Shield.
counsel. Christy Shield, I'm sorry.
Christy Shield. So on behalf of the board, I make the following announcement. The board has taken action in closed session and will make an offer to a candidate. And if that offer is accepted and all clearances obtained, the board will announce the appointment of the board's new executive officer at the next board meeting and in a press release. Thank you.
And with that, we will recess for lunch. Okay, we will reconvene the Physician Assistant Board and continuing our out-of-sync agenda, we're going to go to the Education Workforce Development Advisory Committee. Jed Grant and Charles Alexander, and we have a presentation by the Health Professions Education Foundation, Norlin Aspect.
All right, so I'll just give an update here on the status of PA programs in California. Right now we have 13 PA programs in California, 7 that have continuing accreditation, 2 that have a provisional accreditation, which means they're in the first 3 years or so of their operation, and 4 developing programs. So pretty good. We lost a couple of programs last year, so it's nice to have more programs this year, given the healthcare needs in the state. So if we could have our guest, is she here? So part of retaining PAs in California, after they finish their training or getting them here from other places, is incentivizing them to go to areas that are underserved or helping them pay for their education. So these programs are important, and we thought it would be great to have the board get some information about the opportunities that PA students have to pay for their education before, like in terms of scholarship as well as loan repayment.
Yes. Good afternoon, board president and board members. My name is Norlin Asprick. I am the outreach and marketing director for the Health Professions Education Foundation, and I'm happy to be here to share some information about our programs. The foundation was created statutorily through legislation and was established in 1987. We are housed under the Office of Statewide Health Planning and Development. And as the Health Professions Education Foundation, we provide scholarships and loan repayment programs to health professional students and graduates throughout the state. In exchange for their agreement to receiving the scholarship or loan repayment award, they provide patient care in underserved areas in the state. And as the foundation has grown, and we administer 13 programs, one of which would be of interest to the Physician Assistant Board. We administer the Advanced Practice Healthcare Scholarship and Loan Repayment Program. The purpose of this program is to increase the number of advanced practice health professionals practicing in medically underserved areas of the state. We are funded, with this program, we are funded through grants and donations. We have a grant right now with the California Endowment, which is about to end this July 31st, 2017. And we also have a California Wellness Grant, which ends December 31st, 2017. Some of the professions that are eligible to apply under this program is clinical nurse specialists, dentists, physician assistants, nurse practitioners, pharmacists, and physical therapists. The amount awarded is based on the grantor's specifications, and currently up to $50,000 is awarded to a recipient in exchange for 2 years of service in an underserved area of the state. some of our award statistics from our 2015-2016 cycle as of June 6, 2016. We have, under our scholarship program, we received 99 applications. Of those that were eligible to be awarded was 39, and of those, we awarded 25 based on the funding available. And for our advanced practice healthcare loan repayment program, we received 287 applications, and of those that were eligible to be scored, we had 163, and based on funding, we awarded 39. And specifically, I have numbers that represent the physician assistants that have applied during this application cycle. And we received 68 physician assistant applications. 46 of those were awardable, and we awarded 13 physician assistants due to funding. And I'm happy to answer any questions.
Great.
Can you tell us what the average award is in terms of loan repayment? Is it a set amount, or if they do like 3 years, do they get more, or how does it,
Well,
money per year?
Under regulations, the requirement for service is 2 years. And based upon their answering of the questions and how well they've scored, that will determine the award amount. I don't have the average award amount available, but I can provide that after this meeting.
I was just curious.
Yeah.
Thank you.
You mentioned two programs. The first was Advanced Practice Health Loan Repayment, and the California program, what was the other program?
Oh, so so the Advanced Practice Healthcare program, we have a scholarship.
Okay.
And then the other program is a loan repayment. So that's for professionals that have already graduated, that are licensed, and are currently practicing. The scholarship is for those that are currently in school, but are, once they receive the scholarship award, as an agreement that after they graduate, they would have to provide a service obligation.
Oh, great. And is there a second program, another program after that?
No,
Okay,
not
those two.
not-
Okay.
Not currently. This is
Awesome.
only 2 programs for physician assistants.
Okay.
Yes.
And is that scholarship program specifically just for PAs, or does that for other
For other
healthcare
health
providers?
professionals as well.
Okay. Is there an allotted number for PAs, or is it just you look at the total number of applicants and then?
Yeah, looking at the total number of applicants, looking at how those applicants have scored, and looking also too at the funding available for each of these recipients.
What are some of the scoring criteria that you use for loan repayment or scholarship?
So some of the scoring criteria is looking at, the reasons why they are dedicated to providing service in an underserved area, asking the applicant why they decided to pursue a career in, to be a physician assistant. And basically their just dedication to providing healthcare in the state is some of the criteria that we look at. And we do have an advisory board that scores these applications, and some of those are physician assistants themselves that are looking at these applications.
Are the numbers of applications that you're getting year to year increasing, staying the same, decreasing?
They have increased due to the funding that we received from the California Endowment. Since this is solely a grant-funded program, but because the grants are only for a prolonged period of time, the award amounts will depend, and the award pool will fluctuate. It's depending upon the funding available.
Great.
So the maximum amount is $50,000? And do you have to, does that have to be matched by the location that you work at, or
No.
no matching?
So the area that the applicant would serve is determined under a federal or state designation as an underserved area. And we have that on our website for each potential applicant to enter the address of the clinic or the hospital that they're currently practicing in. And from that map, it would determine whether that's an eligible facility.
And you can also have a site designated if you fill out the appropriate paperwork?
Yes.
I have another question.
Further
Yes.
Do you have do you also score the clinics or the hospital where they're working? Because I know that the federal loan plan reimbursement, they also score into the clinics, and based on that also is some of the amount of money that they're gonna get.
I don't believe we score based off of the facility, but I think there it is determined as long as that facility is eligible, that the recipient can apply. If it's deemed as not an eligible, determined as not an underserved area, then that applicant wouldn't be able to continue on in filling out the application because that's one of the criteria.
Thank you.
You know, I like to applaud the foundation for the work that they're doing because it does make a difference in terms of where graduates go based upon loan repayment, and it certainly does defer the costs of an education to the extent that they can practice in underserved areas. One question I have, you mentioned $50,000. Is that a one-time award for the recipient, or can they apply
They-
as a scholarship and then later on as a loan repayment?
I believe they can. Even for our loan repayment program, as long as the eligibility criteria is met, they can reapply. And that goes for the same as scholarship.
They can reapply?
Yes.
Oh, great.
Is there anything that we could do as a board to help you with what you're trying to do?
I've been working with Glenn, and I had a meeting prior to me presenting today, and it would be very helpful to get this information out to your licensees via an email blast or through a newsletter, other types of social media to advertise our programs. I did want to let you all know that our open application cycle date for our advanced practice loan repayment program opens August 1st, and the application cycle will close for that program on October 14th, 2016. So that would be a prime opportunity to have some physician assistants apply.
Is that something that we could maybe put on the website or send out in one of those blasts that you were talking about?
Yes, we were talking about, I was going to get some information from Norland where we can put on our website, and then we can do a blast certainly as well. So we're working on what information we need to put on our website so people become aware of it.
So if we wanted to get in touch with your program, would we go under the statewide health planning and development, or would we just go directly into Health Professions Education Foundation?
So the website is www.healthprofessions.ca.gov. And because we are housed under the Office of Statewide Health Planning and Development, it is a department website. But that is our web link.
And we're also, we have some brochures in the back as well. We will have those in the office for applicants or licensees that come in.
Would it be possible to put a link on our webpage for them?
I think we're going to work together to come up with language that your organization would like us to use, and then we can have a link to the exact site, but give a kind of a description of what it does, and then link over to it.
Great.
We're working on that.
And are you doing some, I'm sure you're doing, I know, because I work in education, that you're doing outreach to the education programs, the PA
Yes.
schools in California. Can you tell us a little bit about what you do in your outreach to them?
So we have one of our advisory board members, Leslie Howard from USC, and I've been working with him to promote the program at USC, their pre-PA pipeline program, getting young people and those that are already in higher education to pursue careers as a physician assistant. And we also outreach to the other institutions. We are having a partnership with UC Davis, and we will be presenting at their pre-health conference later in October. And that event will not only encompass health professionals that are pursuing careers as physician assistants, but those that are pursuing careers as doctors, as nurse practitioners, as nurses. So it's a great opportunity for us to promote not only the advanced practice healthcare program, but the other 13 programs as well.
Do you have any data on retention of people who are recipients of your scholarships or loan repayment? Do you have any data on how many of those people stay in underserved areas after they've received those monies?
I believe we do have that data. I don't have that available with me today, but I can obtain that data for you.
Okay, thank you.
Thank you.
Just one more thing is, well, first of all, I really appreciate everything this type of programs or opportunities that they provide, especially for PAs. So before I hired a lot of PAs, and some of them they got this type of loan plan reimbursements, and thanks to that, I was able to retain probably half of my PAs for longer than 3 years on community clinics, and that's very hard to keep those PAs when you're competing with higher salaries and especially in private practices. So this type of programs helps a lot to retain, keep having these PAs and provide good care, especially in community clinics and rural areas. So I really appreciate this type of help and support, and hopefully we can increase it a little bit more because
Yes.
also, I know that some PAs are not able to qualify for that.
And another update, in addition to the UC Davis conference that we will be attending, we are also going to be attending the California Primary Care Association conference in Long Beach. So that's another opportunity for us to incentivize primary care providers.
I also wanted to make a note I mentioned about having the site declared. I was able to have Los Angeles County USC declared as a federally underserved site over a decade ago through the statewide health planning. So I'm glad to see that you guys have many more programs to make it available for other PAs and other medical professions.
Any other questions?
Thank you for coming to share this. Thank you for your program and the hard work that you guys do to help increase access to care in underserved areas. And thank you for coming to tell us about that today.
Thank you for having me.
We appreciate your time. All right, jumping around, we skipped item number 9, regulations.
Bob,
Update.
Mr. President,
Huh?
did you want me to do number, the final thing on 14? We had one more thing to do.
More items under 14B,
Okay, sure.
C.
We can come back to them if you want, but
No, go on.
okay. So the postgraduate training program in Fresno that's being conducted in collaboration with USCSF was approved by teleconference, and so I think they have taken their first 2 students. And then the final thing is I wanted to have a little bit of discussion about a program that Georgia introduced a few years ago in terms of getting some tax incentive for preceptors. So when PAs are trained, they go through, generally, they go through a year of didactic education and then a year or more of clinical education where they spend time with preceptors in a clinical environment being taught. Those preceptors typically are not paid. There are some incentives in terms of continuing medical education credits, but oftentimes it's difficult from the administrative aspect to see a benefit to this because sometimes it slows the preceptors down. There's a little bit of a productivity issue. And so one of the ways that this has been addressed, one other issue with it is that the number of clinical training sites and preceptors is frequently a rate limiting factor for the number of PA students a program can accept. And so as a part of means of addressing that, Georgia introduced a bill where there was a tax credit for preceptors that went to the clinic, and then the clinic could determine where they wanted to send that tax credit. And so looking at California with 13 programs, 2 that are still in their first few years of operation and another 4 that will be opening in the next year or so, this is going to become an issue as people are trying to find clinical training sites. And so this might be a way that would be helpful in terms of increasing the number of training slots that are available in California, because we know that about 70% of PAs that are educated in California will remain in California. And so that helps us with our workforce and access to care. So the question really is, we talked about this a little bit before, but should the board seek some legislation to adopt a tax credit for preceptors, which would allow for more people to precept PA students? So one of the things that we might need to do is have a stakeholders workshop to help determine if there's a need to seek this legislation and what the interest is on terms of the stakeholders. We think that DCA is supportive if there's good stakeholder support of this for advancing this legislation. So wanted to put out that information for board discussion and see if maybe we want to plan a stakeholder meeting and maybe get some public input if CAPA would be interested in making a comment.
I have a quick question. Do you know how Georgia went about, who's the payer for that, or how does it work?
So it's a tax credit from the state. So if a clinic, for each preceptor that a clinic has, they receive a $1,000 tax credit. So that'd be $1,000 less in taxes they have to pay for each preceptor they have taking PA students. And there's other states that have done it. There's some model legislation for this on the AAPA website, and there's other states that have done similar things, sometimes giving the individual preceptor a tax credit, sometimes to the clinic, and then the clinic can disperse it how they want. But basically, it's the purpose behind it, if my reading of their legislation is correct, which I'm not an attorney, so your mileage may vary with that, but my understanding is that this really was to ease some of the administrative concern with reduced productivity in terms of having their providers taking students and being able to see less patients. So it's an additional incentive that addresses one of the main issues for PA programs in number of students that they can train and having clinical training sites available in various subspecialties.
So just so that I'm clear, is it $1,000 per PA student or $1,000 per supervisor?
Per preceptor.
Per preceptor.
Yeah, so you're looking at $1,000 a year per preceptor, but some of these large groups, Kaiser, Sutter, Dignity, those types of things, if they have several preceptors, this could be
Right.
a significant amount of money.
Nice. Okay.
But we could do something different. This is just what Georgia did, but I'm just curious if there's some stakeholder interest in this and would help us figure out the amount we need to use, what the fiscal impact would be for the state, whether or not there's legislative support for this, if the stakeholders want to do it. So I'm not sure what the next step should be. Should we schedule a meeting or make a motion to see if we want to have a meeting, or how does that
Have
work?
we discussed anything with PAEA regarding this?
Yeah, PAEA is supportive of this, and there's a link on their website to this legislation, and they have some model language there as well. But it's something that each state has to do kind of on their own.
Or would you want to maybe invite stakeholders to our October meeting?
Sure, we could put an item. It,
Allocate an hour or so to have an open discussion and exchange and
Gauge interest and,
thoughts are.
okay. Glenn, I worked with you a lot on this, well, a little bit on this, and is there anything else that you think might be helpful in terms of us figuring out, or maybe Catherine, if you have, I know you have a lot of experience with the legislature, anything that you think that we need to consider in this sort of exploratory step?
Well, I might suggest a broader approach rather than necessarily coming in with the solution being the tax increase, or sorry, the tax benefit. Do you think that there's been sufficient conversation from stakeholders about what the problem is and what are the potential ways to address it that that might suggest other solutions as well?
So at the national PA, the Physician Assistant Education Association is a national organization for PA education, and this is something that comes up at their meeting every year is how do we address the clinical training sites? And it's one of the main reasons that PA programs get into trouble with accreditation is they don't have enough clinical training sites. And so last year at that meeting, they had an open forum and discussion about it, and one program director came up and said, there's three main issues in PA education: clinical training sites, and clinical training sites. And so it's a huge issue. It's sort of well known. And I suspect that we'll have a robust response from the PA programs in California if we put that out there. But, in terms of other ways to figure this out, the CME credit for training PA students was one way to do that. The means of getting the CME credit to the preceptor is a little bit problematic, but can be done. A major roadblock in terms of a PA program going to a clinic and saying, hey, would you take some PA students is, well, what financial incentive is this for us? Yes, the preceptor has a altruistic incentive and they want to train and give back, and it creates better clinical skills for both parties, but it costs the clinic money in terms of productivity sometimes because you're taking time to explain and teach instead of seeing another patient. And so it's a way to sort of help address the hurdle between the administrative aspect of the clinic and the preceptor, the actual clinician that's doing the teaching.
That's really informative. Given that, I can see having an item to talk about this particular issue, but also including in that conversation the opportunity to surface other solutions. You could potentially have a bill that had multiple solutions in it that that the legislature was considering. So, I think you want to make sure that there's an opportunity for other good ideas to be surfaced as well. And one of the reasons I bring this up, and this is something we I think talked about in a previous board meeting, is that the legislature tends to be a bit hesitant to pass such measures. And so, I think if there are other options that can be demonstrated as well, I think that could be helpful and might provide some more fruitful paths. I wonder if there's, we talked about quantifying this to the extent possible. I wonder if it makes sense to try and get some sort of survey out in the field to see what's what might be holding potential preceptors back from participating, or those who've done it in the past, how they feel about doing it again in the future, or something like that could help make the case. And I'm not sure if that's something that comes before or after hearing, but I think that could be helpful as well. And maybe that's something to probe at a hearing about, how they think that could be done and whether that would be helpful. And then the other piece of data that we talked about is demonstrating that this would work. And so if there's either evidence from, was it Virginia?
Georgia.
Georgia. Evidence from Georgia that it's made a difference, or a survey, again, could show, if you asked them, how much money would you need in order to do this? And you could show that where the legislature could understand that it actually will make a difference.
Okay.
But I think the stakeholder idea is really great. And frankly, I think it'd be a good idea to invite some relevant legislative staff as well to both to observe and be educated about the conversation. So you're already doing some policymaker education in that conversation, but also because they might be able to, to help develop an idea. They might also be able to weigh in on whether or not what's coming out of that hearing is something that stands any chance of passing.
Okay. Other comments, suggestions?
Put it on the next agenda. Maybe we can get in touch with, I believe it was an assemblyman who was the chair of the education committee who was so upset when Riverside got shut down. If he's still in the assembly, he might, somebody from his staff. They're certainly aware of the issue.
So Glenn, I'll get with you and we'll try and put maybe some tools together to gather information before, and then we can have that at the next meeting, set some time aside for that.
Is Georgia the only state that's doing this?
No, other states have done it too. I don't have a list in front of me, but there have been several other states that have done it as well. I think
Might be a
there's
good idea to get what the fiscal impact is on each state.
from each state.
You know.
public comment? Bob, is that okay?
Public comment? Why don't you guys sit up in the front instead of having to walk so far?
Conversation. Good afternoon, Teresa Anderson with California Academy of PAs. I would like to just add a little bit to this. I know last time we talked, you mentioned the idea of doing a white paper about this issue, because this is something that's been age old. I mean, I don't know how far back this goes with the issues about finding rotation sites and preceptors, and it builds upon one thing on the next. In fact, 5 years ago, we did a state action plan, and that was identified in the top 3 as the barriers to increasing access to PAs and to care in California. So that's an issue that we've worked on quite a bit at CAPA, and whatever can be done at every level to increase access to preceptors and rotation sites is just a huge benefit. So we would, as CAPA, would be more than happy to engage in the stakeholder process and also, work with the community or however we look at that, building that, because that's a really significant issue and like to see it move forward.
Great. Maybe help us get the word out for the next meeting so that the stakeholders can have input.
Great.
Thank you.
Thank you.
That's all we have, Bob. Thank you.
You sure?
Yes.
All right, can we go back to number 9 now? Which was supposed to happen at 9:30 this morning. So number 9 is update on rulemaking to amend Title 16 California Code of Regulations. No, we did that.
We didn't do
Well, yeah, we're going to.
Okay.
California Court of Regulations, Section 1399-540, limitation on medical services related to the use of electronic signatures for delegation of services agreement. Christie?
So at the last board meeting, the board had directed staff and council to come up with some regulatory language for consideration in adopting standards for recognizing, authorizing, or authenticating electronic or digital signatures for the delegation of services agreement. Currently, the regulation doesn't specify how a signature would be authenticated or recognized by, enforcement staff. So you need some criteria to develop that, and the board didn't give us any, so we're trying to come up with some language that you could at least look at and discuss. This is an area that is very complex, and we're going to need some time to do some further research, and none of the other boards have actually developed regulations for identifying, authenticating electronic or digital signatures yet. So you would be one of the first boards out of the gate to develop such criteria, so we want to be kind of deliberative in our development of these standards. So we're working on it.
Okay. So it's going to fall on Ileana?
Yes.
So,
But my
Okay.
contractor's board client is also working on criteria, so we're going to try to make sure we exchange information so that we can try to work towards some kind of maybe something other boards can look at as well.
Okay, so now we will go backwards to number 8, discussion of possible changes to the October 17th physician and assistant board meeting and location. Our new council will be on vacation,
Yes, I will be out of the country,
okay?
so, yes.
So we have 2 options. One, getting a different attorney.
I may be available on that date, or it would be probably one of your former PA board councils that could sub in for that meeting. We do that frequently, as you know. When I had my own family issues, Laura subbed in for me for the last board meeting.
Yeah.
So we could have someone cover that meeting. It was supposed to take place in Los Angeles, my understanding, this time, but I don't know whether the board wants to change that. But the board voted previously to hold a meeting in Southern California, probably Los Angeles, on October 17th. And Business and Professions Code Section 101.7 requires the board to have at least 3 meetings a year, 1 in Northern California and at least 1 in Southern California. We've had 3 meetings in Northern California this year, so that's why we had designated the October meeting for Los Angeles meeting. Of course, it can be anywhere in Southern California. So I'm just going to, open it up for discussion. I mean, our recommendation is that you do hold a Southern California meeting, either for the full board or a teleconference location should be made available. That's our recommendation.
So if we did a teleconference, that would just be a room with a telephone, essentially.
Well, you'd have to have a board member there.
Okay.
So for it to be an official board location meeting notice where the board has an opportunity to address the body, there has to be a member of that body at the location.
Okay.
So the only problem, my understanding is that there's going to be some petitioner hearings potentially in October. And if you have petition hearings, the Administrative Procedure Act requires you to see and hear all the evidence before you decide on that petition. So unless you have a location that would have audio and video conferencing, then that would be a problem.
Bob, I don't recall, was there a reason we didn't do it on the 10th? Because several of us are going to be down in that area through the 9th for Kappa conference. So if we're going to do it in LA, doing it on the 10th, or in the Southern California area, doing it on the 10th is maybe a little more convenient for us.
State holiday, I think.
It's Columbus Day is the 10th.
That's what I was thinking.
I don't know if it's still a state holiday, though. Is that? I
Oh.
don't think it is anymore.
If it is,
Okay.
It's not, according to Shelley, it's not.
One comment before number one, we're going to be facing some additional financial things with Glenn leaving us September 1st. We don't know how much that's going to be. Number two, I think I've been on the board 23 years. We probably have had 20 meetings in Southern California or San Diego. The rest of the time, we have elected to have them in Sacramento because of the fact we don't have to move staff down there. We have all our resources here. Nobody attends the meetings in any of the other locations that we have presented them, and that's not going to change. And we now have webcasting, so anybody in Southern California that wants to participate in the meeting could, and maybe, rather than spending the money on doing a meeting in Los Angeles, we could do something similar that the medical board does that has a call-in number. So if there was an individual in San Diego or Los Angeles or wherever, they could call in to this board meeting and participate. I think to suddenly say all of a sudden we have to have a meeting in Southern California after we haven't for a number of years is kind of silly.
Well, the requirement is a relatively recent requirement that you have a meeting, one in Northern, one in Southern, but regardless, the statute says what it says. So the reason we're advising is because it is a legal requirement that you have a meeting in Southern California. Now,
So we violated it for 10 years, and what's happened?
well, I'm not going to comment on, give an opinion on violating. I mean, this is our advice. You're free to disregard it. But 101.7 to us is pretty straightforward.
Okay. Further discussion?
I have a conflict the 17th, so I won't be able to be.
Okay, so
Here or
clearly
there,
we need to
but
change the
if-
date.
If it was on the 10th, that'd be great. And if it's on the 10th, I know at least
Yeah.
4 of us are going to be down there already. So maybe could save some travel costs and.
I'm open on the 10th.
Okay. What day is the 10th?
Monday.
The only thing I'll notice in regard to the previous conversation, Jed, if you want to have legislative staff involved in the conversation, it should probably be here. So you might want to hold that item over for the next one.
That's a good thought. Yeah.
But if we're going to be having hearings with administrative law judge and all of that, then we pick up a bigger tab if we're in Southern California.
No, you would simply get a judge from the Los Angeles office to attend. They have, Office of Administrative Hearings has offices across the state, and they have LA office, the San Diego office, San Francisco, and Sacramento. Fresno too, I believe, yes.
Okay, so that's one not available. Jed, did you say you're not available or are?
I'm not available the 17th. I am available the 10th.
Okay. So the next question is, getting a place to meet down there. I'm assuming we're talking about a hotel. And do we have any cost analysis of a meeting room? It used to be $500 and that was eons ago, so I'm sure it's significantly more.
Well, I think it depends on the availability. We'd have to call a couple hotels to get a bid.
Some of the other boards have hotels that are kind of their go-to hotels in Los Angeles that offer state rate and offer meeting room space. Also, you could look at a school or a government office building that would be free.
Ronald Reagan State Building?
Yeah, I mean, if you can get an office building or a state building that would allow you to use the space, the only thing we would have to get rooms for would be at hotels, and those aren't hard. The hard part is getting the meeting room space at a hotel. That's the hard part. But if you do, and you have the contract executed, then we have for sure a meeting space. The problem I think the staff have had, and maybe they can speak to that, was sometimes the government office buildings would reschedule the room before, without telling us. So that's the only problem with government office space, is sometimes making sure that they keep that space available. I've had good experiences with my other clients at schools. They usually, when they offer us the space, they let us have that space at that time. So I don't know if there are any PA schools that may be interested in hosting, but.
There's a bunch of them down there, and given the fact that we may be discussing
Right.
that something they would be quite interested in, that might be a good idea.
I mean, I'm open to suggestions on this. I've said my piece. This room works perfect. And we have all the resources here. If we violate the law one more time and then make up for it next year. I mean,
Is this being recorded?
Finding a school that's going to have a meeting room in an area where there's going to be a hotel. I'm thinking of my institution, Keck. There isn't any place you want to stay within 10 miles of that area.
Maybe public comment on this, or? Is that okay? Sorry, didn't mean to step on your presidential toes.
Yes, thank you. If you do decide to go to Orange County, I'm on the Board of Trustees of Marshall B. Ketchum University with some very nice hotels very nearby, a Marriott. And I believe, I would have to check the calendar, I can't offer that space, but I feel like there would be free space at Marshall B. Ketchum
On the 10th or 17th?
on the 10th.
And the buildings have to be ADA compliant as well.
For sure, 88. The 17th, I personally can't make it, I don't know, and you can't make it. But anyway, that's just, I can't guarantee it, but it would be a wonderful property.
Yeah, they have a great facility. They're actually graduating their first class about a month later after that. Again, it's getting around. For me to drive to Fullerton in the morning, or leave at probably 5:45 to get there for a 9 o'clock meeting. And I only live 50 miles away.
You know, you could try to get a waiver too, that we do that sometimes for board members, get a waiver for the distance of the hotel. Yeah.
So do we want to, first of all, Mary can't make it the 10th.
No. But I can help in securing a room at Ronald Reagan State Building and not getting bounced.
Okay.
Okay.
So
But
I
that's-
offer up that help.
Okay, but that's,
I may have a problem with the 10th as well.
that's downtown Los Angeles.
Figueroa,
There's
isn't
a
it?
lot of hotels now in downtown.
Right.
It's changed.
Figueroa, I think, right?
No, it's on Spring,
Spring
Spring.
Spring Street,
Third and Spring.
Spring between Third and Fourth.
Third and Fourth,
Oh, wow,
okay.
okay, I know where that is.
So it's near Tech,
After I was just.
you at SC.
Do we want to take Mary's offer, even though she's not going to be able to attend? That's kind of bad.
Did we officially change the meeting date?
Yeah, that's what the next question I had was,
Okay.
did you want to move the meeting date from the 17th to the 10th or
Do we want to look at other dates?
other
October.
dates in
Do we
October?
have a 100-day issue?
Let's see, we're in July, right? 4th. We're going to be a little over that. You know, that really is only for disciplinary cases. If we have an emergency, we can always hold a teleconference meeting on that issue. That's really only to deal with the disciplinary cases, and unless something comes up, I'm not too concerned about that. So, I think you have some openness in October, so if there's a better date. I think Mondays have worked well for some of the board members, that's why we have them on those days, but if Mondays don't work, then we can move something.
24th is good for me too, if it's good for other, I mean, I don't,
The 24th, is that too late as far as the 100 days?
It's, like I said, it's a little over the 100 days, but really the 100 days is really for disciplinary cases. If a case comes up that you've held for discussion and it runs out for the 100 days, we can always hold a teleconference meeting to address that, where you guys can talk about that closed session item in closed session over the phone. So I'm less concerned about that at this point, and since we don't have anything held over from this meeting in particular, I wouldn't worry about that at this point. And we like it to be closer to the 100 days in case something comes up, but the biggest priority is to make sure as many board members can attend as possible. That's what our goal is.
Does the 24th work for everybody?
What happened to the 10th? I lost that.
Some people can't make the 10th, so.
Okay, I just thought since there's going to be people in Southern California already, that might be the,
I know.
A lot of cost, because I think
Yeah.
4 of us are going to have our travel paid by someone else for that day. If cost, and we've had a free room, cost is an issue, that's also.
I'm the only one that can't go, right?
I-
On the
I-
10th?
Yeah, I
Oh,
won't
you
be,
can't do the
yeah, I
10th
have a
either?
conflict on
So
the
there's 2 of us
10th.
out. Is that enough? I don't know what the rule
Could
is.
still have a quorum.
There's no rule.
gotta have a quorum.
Quorum,
that's
yeah.
all.
You need
Just have to have a
5.
quorum, yeah,
you need
5.
Yeah.
And unfortunately, I'm sorry, Dr. Bishop, you don't count.
So if the rest of you can go.
oh, poor guy.
So does the 24th work?
That work for everybody?
Yeah.
Okay, so
I can do the 20th.
we'll make the meeting, I guess I need a motion to have the next board meeting in Southern California on October 24th.
Okay.
And can we leave it open as to where?
Yes,
Until we figure out?
yes. Mm-hmm.
So if somebody would like to make that motion.
I'll make that motion for us to have the meeting in Southern California, October 24th.
Okay,
Second.
okay. Further discussion?
No more changing meeting dates. Once you establish meeting dates, could you try not to change them?
All right, Dr. Alexander,
Aye.
Jennifer Carlquist,
Aye.
Early,
Aye.
Javier Escobar Acosta,
Aye.
Judd Grant,
Aye.
Catherine Hazelton,
Aye.
Xavier Martinez.
Aye.
Robert Sachs, aye. Mary Valencia.
Aye.
Okay, so our meeting will be on the 24th. And our attorney will be back from,
No,
no?
No, I'll be going, or somebody else from my
Okay.
office.
I'm gonna be gone for most of October.
Wow,
I'm only gonna be here for the first week of October, and after that, I'm pretty much gone.
okay.
And then I have another meeting immediately upon return, so yay.
Okay,
Sorry.
so we will work on, Lynn, or have you start calling around and maybe Marion, you can talk about the Ronald Reagan Building or Gay with Ketchum, which would be in Fullerton.
Before we move on, I just wanted to note how really exciting I think the idea of having this at a PA school is. The idea that we could get a lot of engagement from members of the community. I mean, that's the whole point of going to Southern California. So if there's any way to do that, I think that's awesome. And, you know, and one thought, Jed, is that this could be, for your stakeholder process, is that this could be a multiple meeting venture, right? Where we start the conversation there with a lot of input from the field and then move it to more of a policy-oriented conversation up here.
Yeah, I think that'd be great if we could make that happen, particularly at a school. That would be fantastic.
And I would suggest that we think about special agenda items, if we were to do that too, that would, where, you know, places where we might want feedback from the public or engagement from the public, and get a little creative there on the agenda.
Okay. We can do that.
I have a question. Is that a time where you want all of the PA schools to be represented from California at that one meeting?
Well, we'd like them to, but you know, us springing this on them in July for an October meeting, the majority of them are either going to be in didactic or clinical rotations, and the students themselves are not going to be able to participate. That's always been the problem in the past.
Well, I think the school's clinical coordinators would be interested in this, and I don't think the particular date matters to them when the meeting is. They would just want to be involved. And perhaps some preceptors would want to know too. I think it's enough time to clear a schedule for a preceptor or three.
No, it's fine. You know, we should be doing the same thing up here with the programs.
Yep.
Okay, I am totally lost.
Okay, so we're on this one.
Okay, so now we're on number 9B, discussion and possible action to initiate a rulemaking to repeal Title 16 California Code of Regulations, Section 1399, 531, and 1399, 532, board requirements for approval of specialty training physician assistants. Christie.
Okay, so at our last meeting, my understanding was that the board expressed some interest in repealing these two regulations. And in order to repeal a regulation, you have to prove, you know, when you want the regulation, you have to prove you need it. And then when you want to repeal it, you have to kind of prove you don't need it anymore. So in an effort to figure out why I think it was 1983, the regulations were initially adopted, there wasn't a lot of information. I went into the rulemaking file to pull what they call the initial statement of reasons, which is the document that explains the rationale for adopting a regulation, and there really wasn't a lot of information in the package, unfortunately. And so the initial statement of reasons just spoke generally to the requirements for training programs and the need for physician assistants to be exposed to as broad a range of educational experiences as possible, while still allowing an educational institution to retain its discretion to meet these general standards for instruction. However, there was no real definitive explanation for why these regulations were needed at the time. After conferring with staff and Vice President Jed Grant, it appears these regulations were first adopted in 1983 at sections 1399.524 and 1399.525, and then later renumbered to these numbers to address perceived voids in the review and approval of educational programs for the specialty training programs for physician assistants. Simply put, there were no accrediting bodies that specifically reviewed and accredited these types of programs as meeting minimum standards, so the board adopted these regulations to provide oversight and address that need. However, since that time, there isn't an accrediting body, the Accreditation Review Commission on Education for the Physician Assistant, ARC-PA, that does review and accredit these types of programs. So there really is a question whether these regulations are still needed. In addition, staff has indicated that there are currently no resources in place to perform full and qualitative reviews and assessments of these postgraduate training programs. And for those of you who are familiar with accreditation, you know what you have to go through to get accreditation. It's quite an involved process. There are things like a site visit by a qualified visiting committee with members who review curriculum, staff qualifications, facilities, student resources, and whether the course content is designed to meet the educational objectives of the program. Finally, the programmatic or institutional review is performed typically every 5 to 7 years to ensure the standards are continuously maintained. Your regulations don't have any of that. They don't cover any of that kind of minutia and the detail that accrediting bodies now use to evaluate programs and institutions. So it doesn't appear that the current regulations meet the more modern accreditation models, standards accepted by state licensing agencies like the Bureau for Private Post-Secondary Education. Consequently, it is recommended that the regulations either be updated to meet these kind of modern standards or repealed, since the current approval process may be insufficient and could be arguably considered misleading to consumers regarding the level of qualitative review that is conducted by the board before a program is approved. There should be no concerns regarding any of the antitrust issues that typically come along with rulemakings with this proposal, since the board would be removing a potential barrier to educational programs who wish to provide postgraduate specialty training to PAs. Any questions regarding what I've provided? So that's kind of the rationale that I could come up with for potentially re-examining this issue and repealing the regulations. So I wanted to hear if any of you have any ideas or questions about the regulations. The recommendation from staff and myself is if you don't feel like you have resources or need these anymore, then you probably should repeal them.
I think in particular, 532 really is just a redundant reg that we don't need, since these folks are licensed already and they're already covered under the PA Practice Act. I think I can't even imagine an argument against against getting rid of that one. The other one, it is nice to have the ability to approve our own PA programs, but I think the likelihood of us being able to do that in the current healthcare environment is pretty remote. I would make the motion that we repeal both, but I can understand how someone might want to hang on to 531.
Okay.
So I don't know if anyone has a comment on that.
I do have a comment. I think being a part of the residency programs at USC, a couple things that I was just concerned about in terms of the residency programs, the PA board having some knowledge about who is considering or is a residency program. I think as a board, we should know who they are, know what they're doing. So in terms of .531, I probably would love to either have some knowledge, but I do understand the concerns about regulating them. I think that some of those things are out of our purview, but I think that we as a board should know about them, should support them. And of course, they've done everything to make sure that they're above board. And I understand the concern about the accreditation process because I work at a medical school as well. But I don't think that we should have a hands-off standpoint because I have been accepted to programs that were not good, and then having been accepted to programs that were outstanding, I can see how a person who doesn't have that knowledge of what's approved or good and what's not might give them some problems in terms of their thought process, thinking that it was good, and it could be a loss of time, work, pay, etc. So I think we should know about who they are and not take a hands-off approach, as opposed to them just letting them, do what they want and saying that they're a training program. And that's my own just personal opinion.
So you probably want to keep the regulations as is?
I do want to keep the regulation. I do want to have knowledge of who they are, and that's again because I went to a great residency program, and I probably was at the mecca of residency programs some years ago. But I think we should know about them, and because we're the board, I think we should support them.
So could I address that? Is that okay? So, that we already have a reg that says that, and we have several post-grad training programs in California that have not notified the board, and that we have no teeth in this. Because the people that they're training are already licensed, right? From our mission as a consumer protection agency, we are already functioning within that consumer protection aspect because their trainees are already licensed. So really what you're talking about is evaluating the training programs to make sure that they are of an appropriate rigor, and that falls outside of this board's purview. That would be perhaps post-secondary education or something like that. So I agree with you that somebody ought to be taking a look at them, and it's frustrating that the ARCPA is in abeyance on working with postgraduate programs, but I don't think it's, we either need to give this some teeth and keep it, or we need to get rid of it.
With all that being said, I think that because physician assistants are created in the medical model and residency programs do put us on par with how we were created. Again, I do see both parts, and I'd have to agree with you on some part of that, but I do think we need some teeth, but I just don't want to abandon it with that same thought process, because we are created after the medical model, and that is I think it sets us a cut above where our cardinal parts, say the other practitioners, do not have residency programs. And I think that makes us a little bit on par with the way we were designed.
Right, so there's several postgraduate recommendations from specialty organizations. I'm just thinking of the emergency medicine one is through SEMPA. And they have some recommendations, but perhaps the most common, one of the most common postgraduate training programs would be in emergency medicine. It's a common specialty to have them. But I just don't know that that's really within our mission. So I agree with what you're saying. I think it needs to be done. But in terms of protecting the public, they're already licensed. They have to meet all the requirements of licensing. If you get into accreditation, and specifically 532 says that they have to meet all of the requirements of 531, and so that's just a horribly written regulation because they're already graduated from a training program, and you're saying that if we're going to keep these, we're saying that all of the postgraduate programs have to do everything that they do in 531, which is kind of silly because they've already graduated from a program. So I think that this is just really beyond our scope. There are accrediting bodies, there are organizations within DCA that accredit postgraduate programs of various types, physician accreditation of their of their residencies and things like that. It's just a huge can of worms, and I'm not sure that it's really something that we should be involved with deference to your situation.
And I think when I look at 531, if I may, I think those are key things that would be a part of a physician assistant program. I actually had the chance to go back and look at LA County USC's physician assistant residency program in pediatrics, and they followed all of the rules along with the neonatology program, which was a part of our program there. And so the things when we went through the Fresno program, they followed those things to a T. So I think that they can still be done, but I'd have to agree with you in terms of the ARC-PA issue. But I do like the fact that they are following some type of rules in terms of what creates or the educational process for residency programs, which we've held the standard for several years. So to see them doing the same thing was great. But again, I can see both sides in terms of a legislative body.
In terms of enforcement, if we're going to enforce this, we need to enforce it on everybody. Right now, we have one program that's in compliance. I'm aware of 6 in California that have not, counting that one, so 5 additional programs that haven't talked to us, and we really don't know how many there are. So would just say that if we're contemplating keeping these, we should strengthen them and enforce them equally, or we should, if we're going to get into that business, we're going to spend a lot of money and time and effort to do it, then we need to do it fairly for everybody, or we need to just recognize that this isn't really our role.
I think Dr. Bishop had a question.
Yeah.
Well, actually, just a statement. You know, in medicine, we have innumerable fellowships and innumerable levels of post-residency training, or residency training and post-residency fellowship training, and that it's not just California. I mean, if we are going to check programs for what we think is appropriate, we'd have to do it nationwide. And so I'm asking Glenn, do we have resources to do that? And if so, what will be the financial impact on this board of traveling around the country or getting, you know, documents from all these different programs all throughout the country? And I realize we want to standardize education, but really the ACGME for the medical people do that. We just don't have, I mean, the California licensure for medicine doesn't look at anything besides just your medical school. And residency now, I mean, that's going to change, but it's a nationwide process. Just similarly, it just seems like it's going to be a very difficult task. It could be very expensive and beyond the purview of what we can do currently.
And again, I think you can help, the board can help me in terms of the requirements for an approved physician assistant program. I'm thinking that maybe or maybe we're looking at it incorrectly. They listed several items that would make an approved program. And those things, just thinking of the Fresno program, they went through all of those things, and it was, but it didn't get into, and I know that there's a Part B. Could we leave it at that point where these are the things that would be considered from the physician assistant boards? You have to have all of those, 15 requirements. And then from our standpoint, could we say they have all of those things, and that would make them approved from our standpoint? Do we have to have 1399.532? Can we just have the first part, 531, and leave it there to have some type of information and approval from the PA board? And that way we wouldn't have to expend, I get it, lots of costs in terms of going through, tons of money, time, effort that we don't have. Can we just have 0.531?
So if you do that, though, if you keep either one of these, you have to verify and validate. You can't just look at something they submit to you that says they're doing it. You have to actually go and see that they're doing it, and you have to verify it and validate it. So
well, that would be the expectation from the public, that you're not going to approve a program that you don't have any documentary or in-person evidence or testimony regarding the minimum standards, whether they're being met or not. And that's what I was talking about when I was reading my introduction. I was Bureau for Private Post-Secondary's counsel for about 9 years, and I'm very familiar with how they evaluate courses and objectives and the entire minimum standards for educational approval, and it's quite involved. And this is not even close to what I've used to seeing when it comes to evaluating even courses, because the Bureau used to approve not just the institution, but if they added a course, they would have to evaluate that course as well and then approve it to be added to the institutional approval. So even if we're just looking from a course perspective, the amount of information that's currently being requested, I don't know that I would feel comfortable as a regulator that we've actually approved an educational program when we haven't actually collected any data, hadn't had any site visits, hadn't had any experts who are in the field say, yes, that's a program that would train somebody in that particular educational area to meet the objectives of that course. So I think my recommendation was either, as Mr. Grant has indicated, that we need to flush it out more and make it more, rigorous in terms of what's being requested, and then add enforcement mechanisms for those that don't comply or that don't even file for approval, or consider removing it altogether, because I don't know that you're helping protect the public if you're not actually doing a thorough review and examination of the course.
So, and I understand that. My question is, in the event, as a residency program, if we had one person that came back and said, wow, I didn't get anything out of this, and it was personally some problem had happened, as the physician assistant board, do you think that is appropriate also, like for us to have a hands-off, to not know anything about the residency programs? I'm not sure if there's a comfortability of us being a board and not having some type of knowledge about the residency programs, even just from an educational standpoint, to know who's out there or where they're located or how it's run. Or
Most of the boards in the department, the only time they get involved in post licensure training type situations is continuing education. Usually they'll set minimum standards for continuing education providers, or they'll actually approve the providers. Most of the boards are getting out of that latter regulatory model because it is very involved. Even to approve continuing education courses, it's very involved. And so because the primary objective is licensure, to make sure that they're meeting minimum standards for protection of the public, the focus for most of the boards has been the licensure component, and the educational piece they've left to other agencies like the Bureau for Private Post-Secondary or WASC or some of the accrediting bodies. So that's kind of the movement has been across the department, and maybe Shelley has more info. I don't want to throw you under the bus, Shelley. But anyway, that's what I've seen in the last 16 years. There are some boards, like the nursing board, that still do some sort of approval, but it is very involved. Hundreds of people come to those hearings. They're held separately from the board now. And so you have to decide whether, if you're going to do it, and it's a jurisdictional question, and whether you want to continue having jurisdiction in this area, or whether you want to devote your resources to the licensure component. It's really a policy call. But what I'm saying is, if you're going to decide to continue regulating in this area, you probably want to flesh out the standards more and add enforcement components, because I don't believe that this is going to actually provide any additional layer of ensuring people are getting the education that they contracted for or are representing that they got to the public.
what would be the enforcement component? What, for an example?
You probably be looking at things like adding a citation or ability to revoke approval if they don't meet those standards, because that's usually what the consequence is. If they don't meet the standards, then you have the authority to revoke the approval.
And have we reached out to ARC-PA? I know it's been not something that they do, or I know that there's a lot of changes at ARC-PA. Have we reached out to them?
Jed, I don't know.
Yeah,
if you
we've
have.
sent several letters. They're usually not very responsive. They pretty much just tell us that, they don't answer to states. They have said that and on their website, I checked it a couple of days ago, their accreditation of postgraduate programs is in abeyance because they have so many primary training programs. Just as a matter of information for the difference in level of detail that they're after. So in order to get ARCPA accreditation for a PA program, the university where I work, our program just went through it. It was a nearly 600-page document that we submitted to meet their 250 standards for accreditation, and took 2 days for 2 people to come out and do a site visit, and took us several months of preparation. So that is the standard. And so if we're going to do this, we should meet the standard. And I think it's just, you're really taking a big bite by trying to do it. So we could reach out to the ARC again, but they have said that their focus is on, given the healthcare shortage right now, their focus is really on accrediting, the first level training programs, not postgraduate programs. Right now, we're in a phase of rapid growth in PA education where there's lots of new programs opening all around the country. Roughly 10 years ago, there were maybe 100 programs, and there's well over 200 now. So lots of growth. They're very busy, and that's why I think they've done that. So, just give you some idea what you're up against if you want to keep these.
Okay, I think we need to either make a motion or table this to the next meeting because it's already 10 after 3.
I'll make a motion that we that we direct staff to take all steps necessary to initiate the formal rulemaking process to repeal these sections, 531 and 532, and authorize the executive officer to make any non-substantive changes to the rulemaking package and set the proposed regulations hearing.
Do I have a second?
Second.
Further discussion? Okay, Dr. Alexander?
Public comment, Bob?
Public comment, sorry. Getting late.
PA Freeman with the California Academy of PAs, who wholeheartedly supports the motion that was just made. I think if you look at the regulation 1399.531, it was written in 1983, and Jed, as an educator, I think that you would agree that the curriculum requirements from 1983 are not what today's PA program should have. 1399.532, as you said, Sonia said we shouldn't abandon them. It's been 15 years, I think you said, since we've approved one. I think that was abandoned 15 years ago, just based on not needing to. I think that the Fresno program that is now approved by this program kind of misrepresents what you've done. I mean, a PA might go to that program thinking, wow, you guys have approved it, when you really don't know what's happening there this afternoon or anything else once you spoke to Mr. Wu on the phone for 30 minutes. You didn't go, you didn't see the program, you don't know what they're doing today, you know nothing. So that, to me, is kind of a misrepresentation that you've done more and that you've done more due diligence than you've done. So I worry about that for patient and consumer protection and for the PAs that are going to enroll in that program. So I, on behalf of CAPA, hope that you repeal both sections. Thank you.
I do have a question based on what Gay mentioned. I understand that she mentioned that if we put our stamp of approval on them and then something happened, and just with that also, if we don't and they still continue as a residency training program, how will that affect us as a board? Even if we don't and there's something tragic that happens, I guess, you know, on the flip side of that, how would we feel about that as well?
Well, we have enforcement on their license, right? So these are licensed PAs that are doing this. So if there's some gross negligence, we could take action on their license, just like any other licensee.
Will we take action on the program, or would it be?
We don't have authority other than to just withdraw our approval, which.
But there is no approval. I think that's.
Well, I mean, they're basically unapproved programs. So, you know, I guess we could try to make an argument that somehow we have some authority to, you know, seek, and every board in the department has authority to seek legal action against someone non-compliance with the law, but we would have to file some sort of litigation against them because we don't actually have an enforcement mechanism built in. I don't know why these regs were adopted without an enforcement mechanism. It was kind of odd that they'd adopt these requirements and then no way to enforce them. So the only way would be to default the general provisions of the B&P Code, which authorize boards and bureaus in the department refer actions through the director for filing against litigation for violations of state law. And it's like a 17-200 unfair business practice case that you would be taking against them and probably seeking injunctive relief to stop the programs from operating until they got approval from you. But it's a quite expensive endeavor. I've done it with, I actually did litigation with a bureau in the department, and it was a lot of money. And it was very time consuming. We did get the reform we wanted, but it was years of protracted litigation. It's much easier to have an enforcement mechanism in place that you can put in place, and unfortunately you don't have that right now.
I mean, I agree with every standpoint. I'm affiliated with the medical school and I'm a part of the LCME process, so I do understand that part of it as well. But thank you.
Okay, we have
One more.
public comment.
Two more.
Yeah, I think if we put this in context, that really this is on-the-job training. That's really what this is. We keep calling it what we call it, but it's usually 2 to 3 PAs who work with some physicians and receive advanced training. And I think Dr. Bishop spoke to that last time, that that's very different than a real surgical or a medical postgraduate program. So it's really on-the-job training for a stipend that just happens. So I think if you keep it in that context.
One more thing, Bob. I just want to say that, kind of echoing other people have said, if you're going to jump into approvals, you have to jump in wholeheartedly. And I would suggest, to address your concern, Sonia, I think we should never approve a program of any sort unless we approve all programs and in great depth. So I think this most recent approval was kind of an attempt to help out a program that kind of got stuck with some bad regulations in the past. But I think that was a nice thing to do, but I don't think we need to follow up on that with worse. So I think, I agree with you, Sonia, there should be some way for residents to evaluate a program before they go to it, but that's not our purview, unfortunately. I mean, it'd be great if we could do everything, but even the medical board doesn't touch this. It's just way too big for us. Our PA needs to be the one that does this because that's their business, and that isn't ours, really. So I would say don't approve any programs. That way the public has no assurances that anything is above the licensure we've already approved in great depth.
Thank you.
Okay, further discussion? All right, I'll call the vote. Dr. Alexander?
Aye.
Jennifer Carlquist?
Aye.
Sonia Early?
Nay.
Javier Escobar Acosta?
Aye.
Judd Grant?
Aye.
Catherine Hazelton?
Aye.
Xavier Martinez?
Aye.
Robert Sachs, aye. Mary Valencia?
Aye.
Okay, so the motion carries. We will proceed with a rulemaking file to repeal sections 1399, 531, and 1399, 532. All right. Yes. 15. So next item is number 15, discussion and possible action to approve proposed updates of delegation of services agreement questions and answers regarding acceptance of electronic signatures. Mr. Grant again.
I didn't realize this was mine.
Got your name after it.
Yeah, you said my name, and I thought, what? Okay. Well, I think the question here really is, our council addressed this a few minutes ago about the electronic signatures, and if I understand this correctly, this is the document that's in our package is basically a sample delegation of services agreement with some questions, like frequently asked questions attached to it. And one of the questions on the list is, are electronic signatures an acceptable method of signing the DSA? The answer in the document is the policy of the PAB to accept electronic signatures when signing the DSA. The electronic medical record system used should have procedures and protocols established to allow for the validation of electronic signatures. So, to me, I think the electronic signature issue, I know there's I had some conversations with Christy about it that sort of educated me, had no idea it was that complicated. But to me, the DSA is really an agreement between a supervising physician and a PA. And I don't care how they sign it. I don't care if they scribble their name, blue ink, black ink, pink, make an X. As long as both parties agree that however they sign the document is ensuring that they both agree to abide by what's in that document, I think that should suffice. I don't think we really should get into what constitutes a signature and is it electronic, certification, or is it signed, or is it, as long as both parties agree that signature represents an agreement on that document, I think it should be fine. I understand that what I think doesn't really necessarily carry a lot of weight with the law, so that is the issue here. And so there are a lot of PAs out there with electronic signatures on their DSAs right now. And what we do with this, is this okay while we get the regulations promulgated that talk about what an electronic signature is and what the requirements are? Can we use this until then? I think that's a good plan. There are some things in this sample document that I think are kind of out of date and maybe need to be updated. But it's a sample document. It's not meant to be, it just gives them an idea, so I don't really think that matters. So my thoughts on this is that the way this is worded and the way it's put together right now is fine, with the understanding that at some point when we come up with some regulations that talk about exactly what's required for electronic signatures in terms of DCA and those sorts of things, we can update it later, but at this point, it seems okay to me. So I'm certainly welcome to input, and I'm sure council has some comments. No?
Well, I'd like to add a little bit of history to this. A few years ago, whenever we gave a lecture, we said, and make sure that the supervising physician and the PA sign the document. And one of the former members of the PA board called me one afternoon and said, where is that in our regulations? And we went through the whole regulatory book and discovered that it was not in our regulations. So as a result, we promulgated a regulation to include the signatures. That was probably 5 years ago.
2008, I think, right?
Okay, yeah. More than 5 years.
8.
And so now, here we are today. Electronic signatures are all over the place, but we've heard in our previous board meeting problems with that need to be addressed. And I think we should defer to legal counsel. What's our next step?
Well, I mean, the board made a decision that they were going to recognize them. I think the problem from staff's perspective, and Mr. Grant and I have discussed this, is how do we accept that that's something assigned or not? And what are the criteria for that? Because we go up in litigation against someone, we have to be able to say, well, you didn't do this, this, and this, so therefore we don't consider that a valid signed authorization. I mean, with respect, I wouldn't accept an X. Yeah, that X authorizes you to, write prescription medication from a public protection perspective. So, I'm not saying it's not a good idea to move in this direction. I think you have to move in this direction. You have to recognize digital probably is the way to go because from what my understanding is from the IT professionals in our department, they can actually be more secure than a wet signature in some situations. So, but the problem is we don't have any way of enforcing a standard that we will say is acceptable that staff can implement. And that's from my perspective is the biggest issue is how do we develop an enforceable standard that we can defend in a litigation context if we cite and find someone or if we move to discipline a license. So from our perspective, it's not a legally enforceable standard until you've put it in regulation. So that's what we're recommending, recognizing that technology has already moved ahead and we're not quite caught up. We understand that, but from a legal perspective, you have to have the standard in order to discipline someone. So our recommendation is to not implement until the regulation's adopted, but the board, again, is free to disregard advice. And if you want to approve this document this way and then the regulations will catch up to it, that's your call.
So I had thought, I wasn't at the last meeting, and I'm so, yeah, so all Christy and I have to go by is our phone call and a videotape, so. I thought that this had been voted on by the board at the last meeting, and that it's, if I understand from what I'm seeing here, this is just the document that came from the last meeting, is that right, Glenn? Okay, so.
Yes, this was a result of the direction to update licensees as to the acceptance of electronic signatures.
Okay.
So we have the sample, we prepared, we thought this would be the most appropriate way to disseminate that.
Okay, perfect. So I think it looks great. I don't have any concerns about it, other than once we do come up with a regulation that defines what we need, then we can update this at that point. But for now, because there are so many people operating this way, we hate to be a barrier to practice by, not accepting electronic signatures. So I don't really have any other comments other than to say I'm glad that this is there. Bob, public comment?
Public comment?
Christine, how does the medical board or any other board regulate to electronic signatures?
Well, right now, none of the boards have adopted regulations. I think we were talking about this earlier. And so the Contractor State License Board got their law amended to specifically address development of recognition of electronic or digital signatures and giving them authority to promulgate regulations that set standards for authentication protocols and procedures. Because if they don't get legislation enacted, then they have to follow Secretary of State's standards
Very good.
for how to do it. And the Secretary of State standards can be almost impossible to meet sometimes. So sometimes, we have to look at how to implement it, and everybody is catching up. I mean, this is a frequently discussed topic in legal forums and for attorney education. I'm signed up for all kinds of courses and stuff to try to get up to speed on how other state agencies are implementing, but we're clearly not ahead of the game yet with respect to how to recognize it. And I think because we're a public protection agency, we want to make sure we just don't cavalierly adopt a standard that people could maybe fraudulently implement, because this profession, above all others, is totally dependent upon the written instrument for its scope of practice, and that's unique amongst the professions. And so that's why we're proceeding very carefully with how to make sure we implement a standard that is both fair to the regulated community, but also protects the public and makes sure that we don't inadvertently allow people to practice when they really weren't authorized to practice.
It would be a shame to have it be so narrow, and maybe the medical board's not doing it because they don't want to mess with it and make it more narrow than it needs to be. I don't know why other boards aren't doing it.
All of the boards I've worked with have expressed an interest in developing regulations that address electronic and digital signatures. Everyone I've worked with, chiropractic board, contractor state license board, accountancy, the list goes on and on and on.
Will
We're
each
all,
board come up with their own, or won't there be a state?
it would be nice if there was a statewide,
Should be,
I know, but there hasn't. And so I think you just have to kind of jump off the cliff with your parachute and hope you land safely, so to speak. That's, I think, where we're going, because we can't wait any longer to try to implement these standards. So all we can do is try to work within. Contractor State License Board has often been at the forefront of developing they develop their own software. They create their own exams and administer their own exams electronically. So that's why I'm saying I'm working very closely with them and hope to share that information with Ileana so that we can try to work these issues forward as quickly as possible for the clients, because we understand there's this need.
And
But-
can you imagine being an investigator and an electronic signature for the PAB is this, and for contractors?
I
it's
know,
this,
and that's
medical
why,
board it's that.
exactly, that's why, like I said, we're proceeding cautiously, but at the same time understand the need to have it implemented as quickly as possible.
Cautious is a good word. Okay,
Yes.
thank you.
Sure.
But for now, the way it's written, Glenn, from an enforcement perspective, it says electronic. There really isn't a definition of that. If they produce a DSA that has some form of electronic signature or digital signature, that would meet the requirement, I guess.
Well, I think that, as Christy brought up, I'm not an expert. I would not know if that was in fact true. And I think there again, with the investigators who would be looking at this, as well as attorney generals, the question would be who can actually validate or say this in fact is an electronic
It's a
signature?
valid signature.
Valid.
So I think
couldn't.
you'd have to defer to experts in the area. We'd have to hire experts on this until we get a standard implemented. So it'd be a case-by-case analysis like we do with the gross negligence cases. You would have someone from IT or OAS or something saying, yeah, if in this particular industry at this time, that would be a valid way to authenticate it, and that's a valid signature. So there would need to be a bit of that at the forefront while we're developing the standards to be applied in every case.
I think you would have issues with where a physician would say, I didn't sign that. Well, I wouldn't know, okay, that's your word, but how do I know that you didn't or you did? And I think, forensically, you'd have to go in and have a person that would understand what electronic signature is to go in there and say, yes, he or she did not do that, or they did do it.
Yeah,
And
because-
staff is not expert, doesn't have the expertise to do that.
Right, because, the physician might want to get out of a potential sticky situation by saying, oh, I didn't authorize that. So that's why we don't want to get into a situation where we don't have a standard that's defensible.
So this is an interim solution.
Right.
Until we have a definition. And if a case comes forward, then we'll have to get witnesses, get experts and really dig down on it more. Any way to send this up the DCA chain and say, hey, this is a problem for multiple boards. Why doesn't someone higher up the chain take care of this? Please share vigorously.
Okay, are we finished with item 15?
Are we, okay.
Do you want approval from the board?
I would like approval, but I think we also need to address, there was another concern with, am I required to update my DSA? That was, and so we have a sample Q&A about that as well. I'm sorry, when we did this, it came out as a highlight, but for some reason it didn't print. So it's the second to the last question.
Okay, oh yeah, I see it. So I think there's nothing that I found in our Practice Act or regulations that says it should, really doesn't, it's not defined. So like the electronic signature, can't really enforce that. But my preference would be in this is to say there's no legal requirements to update your DSA, but it should reflect current practice.
Right, because if it's not in there, you can't do it.
Right.
So if they end up taking on further responsibilities, they better have a DSA to back it up, or they're practicing without a license.
Exactly. So if you're needing a motion on this document to approve it, I would make a motion to approve with the addition of the additional portion on that sentence that says, but it should reflect current practice.
Do I have a second?
I second.
Further discussion? Public comment? All right, I'll call the roll. Dr. Alexander?
Aye.
Jennifer Carlquist?
Aye.
Sonia Early?
Aye.
Javier Escobar Acosta?
Aye.
Judd Grant?
Aye.
Catherine Hazelton?
Aye.
Xavier Martinez?
Aye.
Robert Sachs, aye. Mary Valencia?
Aye.
Okay, motion carries. Okay, moving to number 16, development since February 2015, United States Supreme Court decision in North Carolina State Board of Medical Examiners versus Federal Trade Commission.
Okay, so the only thing that's happened really substantively since our last meeting is there was a roundtable meeting with the Little Hoover Commission, several agencies from the department, and the director and the head of the, or the assistant deputy for the head of the legislative and regulatory review unit from the Department of Consumer Affairs attended that roundtable. It was kind of an informal discussion regarding barriers to licensure, and that the facilitators were seeking sort of a one-size-fits-all approach to addressing some of the issues raised by the North Carolina case. And I think we all agree that, it's hard to do that when the boards all have different professions and regulate differently in some situations. And one of the things they focused on were, certain types of crimes and whether those were barriers to licensure, meaning if, you had a crime like driving under the influence seems to be a hotbed one, whether that unnecessarily prevents people from being licensed. So, however, the discussion apparently ended up focusing on gathering demographic data to see whether certain types of crimes or ethnic groups were getting denied at a higher rate than others. And so it looked like the roundtable discussion was more focused towards the end of the meeting on gathering demographic data. Now, some of you probably know, this board already collects demographic data, so that's not something that may impact you necessarily, but they may expand the collection of the data to include, types of crimes, which I think would be hard to really collect on a demographic survey, but that seemed to be something that the Little Hoover Commission was very interested in pursuing. So we are expecting to get a summary of the meeting, and when we do, we'll share that with you so you can get some information. The Little Hoover Commission, if some of you aren't familiar, sometimes their recommendations end up as legislation. So that's why we track Little Hoover Commission hearings that affect this department and our agencies, because at some point in time, it may end up as a legislative piece that it would impact the board. So there may be subsequent meetings, and I'll let you know about, or my subsequent attorney will inform you about those developments. Any questions? Okay.
Public comment? All right. Update regarding Medical Board of California activities, Dr. Bishop.
Well, first of all, the medical board would like to take a moment to recognize again Mr. Mitchell's hard work and dedication, and great service to the state and the consumers, and also his great cooperation with the medical board. He'll be sorely missed by us as well as by others. The medical board held its quarterly meeting on May 5th and 6th in Los Angeles. At this meeting, the licensing committee heard an update from staff regarding the board's project to change the length of postgraduate training required for California licensure. Currently, the board requires at least 1 year of ACGME-approved postgraduate training for U.S. and Canadian medical school graduates and 2 years for international medical school graduates. Based upon discussions and concerns, the board members requested staff look into this issue and determine if the board should request that the law be changed to require more postgraduate training. The board is currently looking at 3 years postgraduate training for both U.S. and Canadian and international medical school graduates. The board has held interested parties meetings and will continue to do so to determine if any unintended consequences will occur as a result of this change. This will be something the board brings up at its Sunset Review report. The plan at this time is to change the requirement to 3 years for all graduates. The licensing committee also had presentations on special faculty permits and the board's special programs. The board's Public Outreach, Education, and Wellness Committee also met on May 5th. At this meeting, committee chair Dr. Lewis provided an update on the board's new outreach campaign entitled Check Up on Your Doctor's License. Dr. Lewis noted that staff had already completed some of the activities in the outreach plan. One of those completed activities included a message encouraging state employees, vendors, and contractors to check up on their physician's licenses, which appeared on all pay warrants issued by the State Controller's Office during the period of June 1 through June 30, 2016. You all may have seen this in the bottom of your pay stub. Dr. Lewis stated the message will reach approximately 440,000 individuals. In addition, an article with information about the board and a link to the board's website was included in the California State Teachers Retirement System and the California State Retirees Organization April newsletter, and will again be in their spring and summer 2016 newsletters. He stated the target number of these groups is 934,000 individuals. In addition to this outreach, the board just completed a website tutorial on how to look up a physician. This tutorial is posted on the board's webpage. Staff will begin next working on the public service announcements that would be provided to various media organizations and other interested parties discussing the importance of checking their physician's profile. The medical board was listed recently in the Consumer Reports article, which listed the California Medical Board's website and physician profile as the best in the nation. Although it was ranked the best, staff reviewed the article for suggestions for website improvements and made what improvements were allowable in the law. At the full board, the members discussed a significant amount of legislative bills related to the practice of medicine impacting physicians. The board also had an overview of the Sunset Review process and approved 11 items to be included in the board's Sunset Review report. These are issues where the board would like legislative changes and therefore are bringing them forward in this report. Some of the issues include requesting a licensee's expiration date to be 2 years from the date of license issue rather than the physician's birth month, changes to data reporting for outpatient surgery settings, changes to public disclosure laws, requesting penalties for facilities that do not report as required in Business and Professions Code Section 805.01, and changing the language in the law requiring the posting of a sign in a physician's office. The board held its second annual legislative day on May 11th. The day was well attended by the board, and 5 groups of board members visited throughout the Capitol explaining the board's roles and functions. In addition, members asked the legislative members to post information in the board's outreach campaign. Several legislative members took pictures with board members and tweeted the information about the board to their constituents. It was a very successful day. In addition, Ms. Kirchmeier is organizing a collaboration between osteopathic, physician assistant, registered nursing, and pharmacy boards with respect to telemedicine, cures, opiate prescribing and abuse, and the corporate practice of medicine. The medical board will be meeting next on July 28 through 29 in the San Francisco area. Again, the board continues to be appreciative of the relationship it has with the physician assistant board, specifically with Mr. Mitchell and his staff. The board offers any assistance it can provide to the physician assistant board with any future issues. Thank you.
Thank you, Dr. Bishop. Any comments on the medical board report? Public comment? Okay. Next item, finally, Catherine, legislative report.
All right. So this one is going to be a lot shorter than the last meeting because most of the bills we reviewed this year are dead. So you can see on the third page here, I moved all those guys into a separate category. We're not going to talk about them. And really, I think we only need to talk about one bill today, but I'll just briefly go over the other two. AB 2193, as mentioned earlier today by our DCA colleague, is the sunset bill. It doesn't look like it's running into any problems, so nothing really to worry about there. The PA board shall live another day. The last bill, just to mention quickly, SB 1155. The board looked at this last time around. This would give an honorably discharged veteran a fee waiver when applying for the first time to this board. And staff thought the costs were negligible and minor and absorbable. So we didn't take a position on the bill, but it's doing great. It's probably going to pass. So the bill of the moment is SB 482. This is the one bill that last time around the board decided to take sort of a position on. Our position was watch with some comments to the legislature about some things that we would like to see done in it. And this is a bill that that would require the cures database to be checked before Schedule 2 and Schedule 3 drugs are prescribed. The concerns of the board, as I remember them, could be summarized as a concern about the timeliness of treatment and it noting that it wasn't clear whether other members of a medical team, medical assistants, et cetera, would be able to provide this function. We voted to send a watch letter to the legislature outlining these concerns and asking them to consider changes. That letter was not sent. I received it from staff a week or two before the board meeting, and because the bill had been amended several times since then, I asked them not to send it to the legislature until we could talk about it again and talk about the amendments to the bill. So the bill has had a number of amendments that, in my read, and I think Sonia has taken a look at this too, seem to assuage the board's concerns. And the main thing that I would point you to is a new part of the bill. And let me see, I think it might be on page 6 of. I'm not finding it right now. Page 6 of what we have here. It's listed, yes, as page 6. Right in the middle of the page, you could see a 5A with subsections 1, 2, and 3 below that. And it says that the bill would, that the cures database would not have to be checked, that the requirement wouldn't be necessary if it's not reasonably possible for a practitioner to access the information in a timely manner, and another healthcare practitioner or designee is not reasonably available, and the quantity of the controlled substance doesn't exceed a 5-day supply. My sense is that meets the two concerns we expressed, but I want to check in with you all and see if you think that does. To me, that reads as an exemption for timeliness.
Is the and mean all three conditions have to be met?
Correct.
And does it specify who the designee might be? Could it be a medical assistant versus a physician?
Yeah, so It doesn't specifically. So I contacted the legislative staff for clarification on that and actually got a note back from them that said, I'll read it to you directly, and this is from Senator Lara's staff. He authored the bill. It says, in the Department of Justice's update to the system, they've enabled a prescriber's designee to run the Cures query. Ultimately, the prescriber still has to consult the results of the query as they are the authorized prescriber, but a designee can run it for them. This is currently allowed under the current law, and it will continue to occur if this bill were to pass. So while that doesn't specify, whatever the current practice is, and I understand from Sonia that includes medical assistants and others, that would still be allowed under this bill. So my recommendation from this read is that the board remove the watch position and not send a letter at this time. But if folks have additional concerns, I'd be happy to talk about the bill further.
I'll just say I'm not comfortable with this bill at all. In my practice in emergency medicine, we use smaller amounts, but to require someone that is, even in a clinic, I'm sure Javier, someone can, attest, you've got patients scheduled every 15 minutes, often double booked. So you have 7 minutes with a patient. It's just impractical. We know when we need to consult the Cures database. Should we be using it more? Perhaps in some cases, but if you look at the data we saw this morning, it looks like PAs are perhaps we're heavy users of Cures in the appropriate circumstance. So I don't like anybody in the exam room with me, but me, the patient, and maybe a medical assistant. I don't want the legislature in there with me when I'm taking care of a patient. So I think that should be up to the physician or PA to determine when I need to look in Cures and when I don't. I don't want them telling me that, and I certainly don't want them punishing me for not doing it when they think I should.
Further discussion? I know, having used Cures a few times, it takes a good 5 to 7 minutes to get to the point where it tells you no patient available. And that's 5 to 7 minutes that you could be spending taking care of the patient. It's not user-friendly at all, even though we get to pay for it. So, I don't know, when I see this many amendments on a bill, I begin to wonder if any part of it is any good.
Personally, I'm not making a motion here, but I would oppose this bill. I don't like it. But I'm not sure the board wants to take that kind of position, but I don't think it does anything to protect the public that we're not already doing, but it does do something to punish the providers. I think this is the stick. I would prefer the carrot. So.
And Jen, I know you weren't here when we talked about the bill last time. We had, and I limited these comments to talk specifically about the amendment, but we did have a fuller conversation about both the pros and the cons of the bill, including that it's supported by, it's a very long list of supporters, and at this point, only one opponent, the California Medical Association, but based on public protection and concerns about prescription drug abuse, it does have a long list of supporters.
Right, but those folks, if they're going to have to wait 3 hours, for their scheduled appointment because we're checking Cures on every patient, they're going to wish they didn't support it, right? And because you're taking the decision-making capacity from the provider in terms of when they need to check this and sort of mandating that it's always checked. And anything that gets in between the relationship with the patient and the provider, I think, is a bad idea.
Mm-hmm. All right. Well, we had a watch position with specific notes about an issue or two issues really that have now been taken care of in the bill. So I think it's probably not appropriate at this time for us to send a watch letter on that topic, or those topics, but we could take a different position on the bill. Does anybody want to make a motion?
Before we have a motion, Dr. Bishop, does the medical board, have you guys talked about this bill at all?
We've talked about it, not with respect to the new amendments. We will be talking about it at the meeting coming up at the end of this month. I'll certainly bring these things forward, that there's concerns about this. And obviously, as I think I mentioned last time, the emergency room physicians are the ones who will probably be most impacted by this, although many primary care clinics will be also involved in it. So luckily, I'm one of the exempt groups.
Yeah, there are a number
as an
of
anesthesiologist,
exemptions.
but no, I recognize the issues, and I think it should be. We'll talk about this at the medical board level too, because there are definite concerns.
I have a comment. So I'm kind of agree and disagree about some of the comments. It's part of it is on my previous practice. It's a lot of the PAs. Well, we were checking the cures and just some of the patients, and we were like having more freedom to pick and choose who can really need to check all this type of information. Currently, in my current practice, is we need to check it for every single patient, and yes, I'm agree. It's a lot of time consuming, and with the 15 minutes allowed or 20 minutes allowed in some patients, it's very, very difficult. And right now, we are using a lot of the nurses or medical assistants to support us into all these, but again, we need to allow them to use some of our passwords. So it's a little bit difficult sometimes to trust in somebody else, and so that's why it's hard to right now to comment very well into this.
Okay, well, I'm going to make a motion that that we remove our previous watch position with specific suggestions to the legislature. Is there a second to that motion?
I second.
Further discussion? Public comment? All right, we'll vote. Oh, public comments?
I'm not fast enough, sorry.
Yeah, run fast.
I know, speed up here. CAPA has concerns on this bill. We are working with the author's office. We don't have an official position in, but there definitely are some concerns in the bill. There is a long list of supporters, but a lot of that is law enforcement. A lot of the provider groups do have concerns with how this is going to impact patient care, patient flow, access to, are providers going to be less likely to prescribe? How is pain going to be managed? So there's a lot of questions on this bill. I understand why we would watch it and have concerns, why you would also watch and have concerns. But as far as we're concerned, we are closely watching this. We are working with the author's office on a couple of amendments. And as you can see in the last set of amendments, they've changed it, and it used to be to consult with the CARES database at least annually. So prior to seeing each patient, if you plan on writing for Schedule 2, and at least annually thereafter. And that has since been changed to at least 4 months after, so every 4 months after. So, I mean, I think that when we're talking about how does this impact patients, we have to be, and providers, we have to be very, very thoughtful. But again, this is the climate, the political climate, the political will behind this bill is very, very strong. So, although as a provider association, we're working on trying to make it a little bit more provider friendly, it's a very challenging task. So, don't think for a second that there's not a lot of provider associations out there not working on this, because we are. Thank you.
Could I just, a thought came to me as not from your standpoint, but a thought came to me thinking about this too from another standpoint, is that what this bill is intended to prevent is doctor shopping by patients, basically. And unfortunately, the data is very clear on this. If the physicians don't prescribe the drugs, they'll go to heroin on the street. And so the goal is to decrease addiction and opiate overuse. Unfortunately, I don't know what kind of impact this will really make because the data is very clear that as the prescription drug availability has tightened, the heroin use has increased just the same. So this will just push people away from the prescription drugs into heroin, I'm afraid. But I think it's a good and well-intended bill. I'm just not sure how much it's going to really help the whole situation, unfortunately, because I strongly feel we need something to be done, but maybe this will be a little piece of it that will help.
I think this will probably be the first of many, and we're with you. The intent we're supportive of, but the delivery might be needing some fine tuning.
Okay, further discussion?
Glenn, what does the enforcement piece look like on this? So if this bill were to go through and then you have to look at, an enforcement for somebody who didn't document that they didn't consult cures or that they did, or as a violation of this, is that going to be are you going to see a lot of enforcement action on this? What is your take on
Well,
this?
I think we're seeing a lot more of these type of complaints coming in of patients that have been doctor shopping or PAs that have been transmitting scheduled drugs and they haven't looked at the report or they don't care what they're doing with the patients. But it involves usually having a medical consultant look at the reports and then trying to disseminate exactly what the meaning of that report. So, I mean, it is a time-consuming process to look at the report.
I think what I'm asking you is, do you anticipate that there would, given all of those types of complaints, do you anticipate that there would be much more enforcement action if this bill were to be enacted? That they would sort of give teeth to the complaints in terms of more providers now being subject to discipline because of this bill and its various requirements?
Yes and no. I think we're still, if we didn't have the law, which we don't right now, we're still disciplining PAs that are not properly transmitting scheduled drugs. And there's patient harm or there's a problem with what happened to a patient. I don't know the impact. If the law passed, it would be probably another provision added on to, if there was a discipline, another violation of the law.
It specifically says that there's not a violation of the law,
okay.
that this section does not create a private cause of action against a healthcare practitioner. That's newly added. Before it said that this couldn't be, I believe it said this couldn't be the only cause of action, that there had to be something else included. But this doesn't cause a private cause of action. It only allows for licensing boards to administer sanctions.
So there is some teeth to this. If it's going to administer sanctions to the provider, we can vote on your motion, but I personally am opposed to this. I think you're, again, punishing the provider. First, pain got made a vital sign because we didn't provide it enough, and then we did what everyone wanted us to do, and now there's an epidemic. Maybe we ought to just let the providers make the decision.
Would the sanction be upon a patient complaint that they didn't get the medication? Is that where the enforcement or sanction would come in?
Or there was patient harm because they overprescribed
Or they didn't check cures and they told them no, and it didn't. Basically, you're making them check cures for every patient. So, if I don't check cures and there's a problem, either too much or too little, I'm subject to penalty, and not sure I like that idea.
And I believe that's where the designee comes in to try to alleviate some of the time. Is that correct?
Anyway, we have a motion. I just wanted to add my 2.37 cents.
Okay. Or call the roll.
Can we repeat the motion?
Yeah, the motion is to remove the previous watch position and specific recommendations that we intended to give the legislature during the last meeting. And
Remove it.
yeah.
Okay. Dr. Alexander?
Aye.
Jennifer Carlquist?
I'm not sure what we're actually voting on. What recommendations are we, so they're not even applicable anymore because
Correct.
the language is not in there? Okay, aye.
Sonia Early?
Aye.
Javier Escobar Acosta?
Aye.
Judd Grant,
Aye.
Catherine Hazelton,
Aye.
Xavier Martinez,
Aye.
Robert Sachs, aye. Mary Valencia,
Aye.
okay. Motion carries. We will remove the watch.
If I may, I just want to keep this open in case if we could at this time have a different motion on this bill if somebody wanted.
I'll make a motion to oppose.
Is there a second?
I'll second.
Discussion.
I would note that I think it's not consistent with this board's mission to oppose this bill because this board is focused on consumer protection. I think it's perfectly reasonable for CAPA to be looking at at how it affects physician assistants. But my sense of our mission is that because we are focused on consumer protection, we should be weighing the consumer protection element of this bill higher than the burden on the physician assistant.
For me, it goes to an access issue. So if I have to spend time muddling around with this on every patient, I have less time to see other patients. And many times, pain-related complaints, patients have unique demands that are quite time-consuming, and this will sort of increase the amount of time I have to spend on that. So to me, it diverts me from providing good patient care where I need to, and provides for burdensome documentation requirements.
Which ultimately takes away from taking care of patients, which is what we're here to do, and protect the consumers. So I think it does support the mission in that respect. I totally support what you say.
Yeah, and in that, additionally, I don't think it really protects anybody. Because cures oftentimes is not accurate. I've had patients with bottles full of opiates, and I pull them up in cures and there's nothing there. I don't have, I check cures often in my practice, but I don't have a lot of confidence in it, and I certainly don't have enough confidence in it to attach a penalty for not using it.
Well, that
Comments from others?
definitely adds a little, because I think we're under the impression that the cures, it's a cure, but if they're not going to implement or input the information into the system, then you're correct. It's not doing its job per se. But I think I was under the impression that everybody was supposed to or mandated to put the information into the cure system. But if they are not, then that poses a different problem and a bigger problem.
It does go in the system, but it's routinely 3 weeks or more behind, and so it's not an accurate reflection. If they've been to 4 different providers since then, you really don't have accurate data to make a decision. And I'm just curious about the 140 complaints that were not related, or they're related to not prescribing medications or overprescribing. Is this bill going to increase that number of complaints?
Likely would.
That remains to be seen. It could.
And I did check with the medical board, and their complaint level has gone up greatly too about not having access. I would just like to say at this point in time too, though, if there's anybody who has any thoughts that this bill has any positive value, by saying an opposed position, you essentially close the dialogue. So if you do think there's any value to it, and you would want to say oppose unless amended with specific things you want to see amended. Otherwise, you just close the dialogue, and they just ignore you from the future on, and they will go ahead without any input from you. So just want to say that there's an unintended consequence of that position too, although my knee-jerk reaction can sometimes get the better of me too. So at any rate.
Well, I don't know if it's knee-jerk. I read it a few days ago and reread it. I still don't like it. I just have jerky knees, I guess. I just think this is a stick. And I think anytime you have a bill with this many amendments, you probably ought to look at the whole thing, right? And the list of amendments that I would make just looking at it here, there's 3 or 4, and I don't think that's really something I want to get into helping this guy write his bill. I just don't think that it's going to help anything, and it's not going to help protect anybody, and it's going to be a barrier in practice. And that's why I think just an oppose.
If it's helpful, I'll note, this is a pretty common number of amendments, and this is really commonly how most bills go through the process.
Oh, well, okay.
I'd be curious to see what CAPA, what their, if they support or your concerns about this amendment would be.
As I said, we don't have an official position, but we do have concerns. Several of the concerns revolve around the designee part was a big deal for us. And right now, yes, you can have a designee, but the report goes back to the provider. So like your MA can't run it, put it in the file, bring it to whatever. I mean, I know they're not paper copies typically, but it's just sort of how that process looks in practice, in day-to-day practice, so what that looks like every single time.
So they cannot?
The MA can query.
Okay.
But the report goes right back to the provider, and that's how it works right now. Nothing in this bill will change that in the new bill. There were several things. So one of them, and I don't have the language right in front of me, but one of the issues had to do with, this is actually a real example, 2 PAs in the office, and it times you out. So you can be in there and whatever, you forget your password, or you forget a cap or whatever, and you get locked out. So had a colleague said, hey, can you run this for me on this patient? So doing the right thing, checking the database. And this bill particularly says if you run it for any other reason than care for his or her own patient, you can be disciplined for that. Well, that's a problem because you just asked your colleague to run this for you for this patient. You're not if you are the colleague, that's not your patient.
Are you now the designee?
So in that case, it would be are you running it for any other reason? So we did talk to the author's office about that and try to clarify that. They switched it from annually to 4 months to comply with CDC guidelines. So CDC guidelines, we felt, let the medical board guidelines take, they're less than a year old. Why don't we give those a chance to work? So there were several things that we worked on that we continue to work on with the author's office about our concerns. It's like just sort of the nuts and bolts of this. While we do understand the intent and we want to be supportive of curbing, the epidemic, we all know there's one. That's not a secret. It's how we go about doing it. So sometimes you look at a bill and you just go, okay, we have it, and there's been a lot of conversations on this bill. It did turn into a 2-year bill because there was a lot of conversation, and not all of it was by the providers.
Just curious, the example that you just gave in terms of the colleague pulling that, would the colleague now be the designee in that situation, or not?
I guess by default they'd have to be, but as the way the bill is written, it explicitly says if you enter the database for any other reason other than care for his or her own patient, a designee would be somebody, maybe they are the MA, that's their job, blah, blah, blah. It's a different setup. It's just, it's sort of messy. It's just written kind of messy in that regard. So those are things we don't love a lot of the stuff in the bill. One of the things that we really looked at was making sure that it's tied to the patient, not the prescription, because you don't necessarily want to have to look every single prescription. So, there's concerns. We're working with them. And we don't have an official position, and, it's because we continue to work with the author's office on this. Does that?
Yeah, thank you.
Okay.
I appreciate it.
And just because we didn't go over this in this meeting, for those who weren't with us last time, the bill has exemptions. The one that I mentioned where if all of those conditions were satisfied, that it was timely and a designee checked it, and it was a 5-day supply. The other exemptions in the bill are if the patient is receiving hospice care, if the patient is being treated for a surgical procedure, if the patient is being treated in an emergency department, or during an emergency transfer.
Okay.
What paragraph are you on the emergency department? I didn't catch that.
So page 5, if you look down at 1, that says, if a healthcare provider prescribes, orders, or furnishes a controlled substance to be administered or dispensed to a patient while patient is admitted to any of the following facilities or during an emergency transfer, and then it shows the facilities for a transfer, and then 2 below that shows specifically if they dispense a controlled substance in the emergency department of a general acute care hospital, so long as the quantity is under a 7-day supply.
You don't see that?
I'm not,
On page 5 at the bottom at the bill.
oh, you're looking at the language in the bill, okay.
Look at the bill, because that's what controls, not,
Yeah.
not the legislative analysis.
It's not in the analysis, okay.
It starts at line 35 on page 5 of the bill.
So page 5 and page 6 outline the 5 exemptions, and that starts with halfway down the bill. It starts with number 1, which is about emergency transfers. Number 2 is in an emergency department. Number 3 on the next page is when it's treatment for a surgical procedure. Number 4 is receiving hospice care, and number 5 is the general issue of timeliness, and if a designee is not available to look as well. So those were the author's efforts to address the issue about timing and patient safety.
Still don't see.
Does anyone else have any thoughts?
I have a question.
Yeah. Mm-hmm.
Since CAPA's working with the author to make changes or amendments, where is this process at right now? Will it be voted on this session or not?
So the legislature is in recess right now. They go back into session on August 1st. They are in session for 1 month.
Right.
And then it's over. So they've got 1 month to move this bill. I believe, is it in approps? Yeah. So all it's got so left over is Assembly appropriations and the Assembly floor, and then it'll go back to the Senate for concurrence. Those are 3 places where amendments, substantive amendments, like what we're discussing, are unlikely to happen.
Okay.
So basically, the time for amending this bill is mostly gone. It still could be amended at this time, but it's a little rarer to see amendments this far along. Yeah.
So just to clarify, Jed, your position, that the reason why you have a problem with this concept is the fact that it kind of interferes with the professional discretion of the licensee to determine when a patient's medical history presents where you need to do the checking at that time. Because currently, my understanding from working with other boards and with this board is that if somebody should have checked cures and they didn't, we could still discipline them under general unprofessional conduct provisions and potentially, depending on the facts of the case, for overprescribing. And one aspect of looking at overprescribing is the failure to check cures. And that is something that I've heard with other healthcare boards, that their concern with setting a rigorous check every single time is that they'd be taken away from providing patient care timely and exercising their discretion to determine when to check, because certain flags present with respect to a patient at their doctor shopping or something like that. So is that kind of where you're coming from with respect to your opposition?
Yes, and the requirement to document in the record every time I don't check it. It's just an additional burdensome requirement for documentation. So I think this should be left to the provider. There shouldn't be a punishment for not checking, and I shouldn't be required to document when I don't check. And I shouldn't be required to check it every time. And the other time requirements for checking in my personal place of practice are difficult.
Further comment? Okay, we'll call the vote. Dr. Alexander?
Is this to oppose? Okay. These arguments go on and on, and I get lost where you guys are. Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
And just for clarity, this is to oppose our vote for the cures,
No, it's to oppose the bill itself.
to oppose the bill, right, AB. Aye.
Xavier Escobar Acosta,
Aye.
Judd Grant,
Aye.
Catherine Hazelton,
No.
Xavier Martinez,
No.
Robert Sachs, yes. Mary Valencia,
Nay. Nay, sorry, no.
okay. So we have 4 noes and 6 yes.
Passes.
Passes. So we will oppose this bill. Now, does that mean we are going to direct staff to write a letter opposing, or?
Typically.
Yeah. And we could include in that reasons why, or just say that it's opposed at this time.
I'd like to include the reasons why. I mean, because
Yeah.
when I first started, I thought it was clear on some of the key points, but then after everyone included more knowledge about it, then I no longer could support that. But I'd like to make sure that they know the reasons why.
Do you want to articulate those for, or Jed, perhaps, do you want to articulate them for Glenn?
I don't, I think Christy did, but.
Yeah, I was trying to do because I was anticipating.
Yeah. So I would say that I don't like the time requirements for how often we have to check. I don't like that it places a barrier between the patient and the provider. I don't like that it removes some provider discretion as to when it's appropriate to check. I don't think it adds any additional patient protection because there's already a means of address for that if there's overprescribing. And adds burdensome documentation requirements to an already heavily burdened.
It appears that it's not updated very frequently. That was one of my main concerns.
There's a delay in update, so it may not be accurate when I consult it. You know, if the patient has filled prescriptions in the last 3 or 4 weeks, they may not be in there, so may result in overprescribing.
Okay, so thank you for that. That's helpful. It's just a long letter now. Lots of bullets. So may the letter reflect all of those points, including Sonia's. And can staff send this letter within the week?
Yes.
Okay.
Can I also add the information about the designee versus if it's not appropriate for you to view this chart, you can be liable, or whatever that was, the clarity which Kappa gave input about. I'd like to know, because I'm thinking that would now be their designee, but possibly it could not. So some clarity about that as well.
Or maybe the medical assistant, if they're going to be the designee, they could have their own separate login, because I would worry about giving my login to anybody in the office.
Right.
Because how do I know if they're looking anybody else up and then I'm legally responsible and penalized? So I don't think that's the way to go either.
I think that might be outside of the scope of this bill. That might be a separate concern about the bill, but probably addressing a different part of CURE's policy.
Or the penalty. If now, as a coworker, they asked me to do this, and I could see how that could be a problem. That now it's not my patient, but now I'm drawn in a different way. Am I now liable for going in to look at your patient as opposed to mine? So, just the wording. Now, my designee, then I would not be in trouble. But if I weren't a designee, then I'm looking up information, and so it just adds a whole nother layer that I wasn't aware of.
Thank you all for that. Glenn, do you have what you need? Okay, great. So before we leave the legislation, I just want to request in the future that that staff prepare for transmission to the legislature letters from the board within a week of the board meeting.
Okay.
Thank you.
Okay, anything else for legislature?
No, that's it.
Okay. Items for the next agenda. We're going to have discussion about expert witnesses. We will,
So that was just for clarification, to staff, the board would like something, a discussion regarding how the board recruits and retains expert witnesses, and whether there's any training that's done with respect to expert witnesses.
Okay, we use PAs and physicians, so is it PAs? You,
Both, I think,
Okay,
right?
all right.
Didn't you want both? Okay, yes.
okay.
so our
So how
next,
you evaluate, sorry.
our next board meeting will be
Right.
October 24th in Fullerton at Ketchum University. Public comment, but short. We're running very late here. It's 4:15.
One more public comment on legislation before we close. SB 137 was enacted on July 1st, and it's just really important that everyone knows that that's a bill that will mandate health plans to list PAs as providers. So really important to the profession, and I wanted to highlight that.
Awesome.
With regard to Ketchum, I don't have the authority to cause that to happen. I will
Okay.
check on that and get back to Glenn.
Yeah, I think we were going to leave it open as to which location, depending on what we could get.
Please be aware, anybody can offer agenda items to the staff. One thing that occurred during this meeting, I would like to direct staff to get the agenda packets to the members at least 10 business days before the meetings. And any subcommittees that have documents that staff needs to reproduce, to have them to the office within 15 days before the agenda goes out and the packet.
The only thing, you said 10 business days packets?
Yes.
The problem with that is that the agenda has to go up 10 calendar days before the board meeting. So yeah, it's 10 calendar days, so
15 days.
you probably want to make the packets, I would say, if we have to post 10 days before, and usually this staff posts it, 12 or 13 days before? So I would say 10 days or 9 days. What do you think, Glenn? What's a week at least?
Business,
A week before the board meeting?
yes.
A week being 7 days,
Yes.
because we're running into getting them 2 to 3 days.
I know,
before the
I
morning
understand.
of.
I'm getting the same time you are, so I understand what you're saying. But I think the problem with getting the packet out before the agenda's posted is we don't know what the agenda's gonna look like before the packet. So usually the agenda goes up, or we've finalized the agenda through the president, and then that once that's finalized, then the packet can be put together. So I wouldn't recommend it to be put together before the agenda's been actually posted.
Okay. We just need to clean it up so that the members are getting the appropriate information sooner.
Okay, so one thing you could do is put the agenda up a lot further in advance.
Okay.
So you could maybe target your agenda for 2 weeks before the board meeting, and then your packets to be done at least 10, and to the members at least 10 days before the board meeting. How does that sound? Does that work for everybody?
Sounds good.
Okay.
Okay. A long day. Thank you, everybody, for their participation. Thank you, Glenn, for 31 years.
Thank you.
Enjoy retirement, and if you want to come back as a retired annuitant,
I think so.
you're certainly eligible.
Thank you for the offer.
At this time, I will adjourn the Physician Assistant Board. Thank you, everybody. Stand adjourned.